to my channel. So this video is going to be about my study vlog of subsequent 3 days, wherein I will be productive for my law studies, and I am basically preparing for my exam of Hindu law. And in this video you will see that I am completing the Hindu Adoption and Maintenance Act, and I'll also be starting with the Hindu Succession Act 1956. So this is day 1, and herein I am doing some judgments. So basically the printout that you were seeing in the beginning of this video was related to section 11 of the Hindu Adoption and Maintenance Act. If you remember, and if you have seen my previous video, then I did let you know that section 11 deals with a provision that if there is a family, if there is a Hindu family wherein there is already a biological son, then that family is not entitled to adopt a son, but they can adopt a daughter. And this is also in the case of a biological daughter, wherein if a Hindu family has a biological daughter, then that family cannot adopt a second daughter under section 11 clause 2 of this act. But I found this provision a little absurd, so I did some research and tried to find out what was the logic behind it, and are there any judgments in contravention to this provision. So the printout that I am reading right now in this video is related to this concept, wherein there are several judgments in this regard. So the very first judgment in this regard is Sandhya versus Union of India. In this case, basically the constitutionality of this act, the constitutionality of this section 11 was challenged in this case, wherein the court held that this section does not contravene to the provisions of Article 14 or Article 21 of the Indian Constitution. So basically these provisions are constitutional, and hence there was no revision in it. However, after all my research and hard work, I came to know about two important acts, which are the Juvenile Justice Act of 2015 and the Guardianship and Wards Act of 1890, which actually enable a family to adopt a son even if they have a biological son, and to adopt a daughter even if they have a biological daughter, irrespective of their gender, caste, creed or religion. So there are several judgments wherein the court actually gave the opportunity to the families to adopt in this way using the Juvenile Justice Act of 2015 and the Guardianship and Wards Act 1890. But again, the decision of the court actually varies from case to case according to the circumstances of the case. It is more based upon providing a home to a homeless child rather than a kid to a childless couple. So I understood that with these provisions of 3 acts, that is section 11 of the Hindu Adoption and Maintenance Act, the Guardianship and Wards Act 1890 and the Juvenile Justice Act of 2015, the court has a discretion in this regard to give the judgment according to the circumstances of the case on the principle of equity and justice, and also keeping in mind the welfare of the kid being adopted. I also made this mango shake that was really delicious. So here I am doing judgments related to section 1 to 11 of the Hindu Adoption and Maintenance Act. Basically I did 4 to 5 judgments which are related to this section, wherein the first judgment that I am just writing is Gisa Lal versus Dhapu Bai, which is related to section 9 of this act. It says that if an adoptive mother is present at the time of the ceremonies of adoption or at the time when adoption processes are being held, then that is equivalent to the consent of the adoptive mother. Then at 9:30 around I started my another judgment to write, that was Dhanraj Jain versus Suraj Bai. It is related to the concept that stepmother in section 9 of this act does not include a real mother. It says that basically only a real mother of a child can give him or her for adoption, or only a real mother can give consent for adoption of a child. Stepmother in this regard is not included in this section. So this is day 2 of this vlog, wherein I finally completed the long-awaited the Hindu Adoption and Maintenance Act. It basically took me 3 days to complete it, but finally I completed it. It was basically an easy act, so it was not a very difficult act, so I could have done it easily in 1 day only, but I don't know why I took 3 days. I don't know. Basically the judgments and the research part took me a lot of time, so but that's also worth it, so I don't feel guilty about that. So let's move forward. If you're wondering what I'm doing just right now, so this is my iPhone cover, and there was some problem with this cover. I mean, if you see this video, there is some doubling effect by this cover's lens, wherein if I record it without this cover, the clarity was so good. So I eventually decided to remove this cover and got another cover for my phone. After that, I got back to my work. I revised whatever I did the previous day and started completing my Hindu Adoption and Maintenance Act 1956. So basically here I was studying about the relation back theory, which is related to section 12 of this act, and also section 13 to section 17, which was a part of the adoption provisions in this act. If I tell you a basic overview of this topic, so this basically theory has been abolished as for modern Hindu law under section 12 of the Hindu Adoption and Maintenance Act. So basically here I started with the last topic of this act, that is maintenance. Maintenance is basically provided to 5 people. Firstly, wife. Secondly, daughter-in-law who is widowed. Thirdly, the children. Fourthly, the adult parents who are unable to maintain themselves. And fifth, the dependents on deceased people. So basically, maintenance of wife is given under section 24 of the Hindu Marriage Act, section 25 of the Hindu Marriage Act, and section 18 of the Hindu Adoption and Maintenance Act. If we talk about section 24 and 25, that I had already completed when I was doing the Hindu Marriage Act. And basically section 18 of this act tells several grounds wherein a wife can demand maintenance and separate residence, and clause 3 of this section also tells us about certain grounds wherein a wife is not entitled to gain maintenance or separate residence. So basically I was doing a case law in this particular video whose name is Ketha Kulangara Kunni Kanan versus Nelatham Vetil Malu. This is the case of 1973 and it relates to section 25 of the Hindu Marriage Act as well as 125 of CRPC, which deals with maintenance. After that I did some more judgments and went to sleep. So I could complete till section 4 of the Hindu Succession Act today, and I will be doing the rest of the sections tomorrow in the morning. So stay tuned for it and see you in the next vlog. Thank you so much for watching my vlog.